Someone going to sit here momentarily? The Judiciary Committee will come to order. Without objection, the chair is authorized to declare recesses of the committee at any time. The clerk.
I object.
Yeah. It's the same thing. Yeah.
No, the recesses at any time.
Just say the clerk will call.
Okay, the clerk will call roll to establish a quorum.
Mr. Smith?
Present.
Mr. Sensenbrenner? Mr. Coble? Mr. Gallagly? Mr. Goodlatte? Mr. Lundgren? Mr. Shabbat? Mr. Issa? Mr. Pence? Mr. Forbes?
Yeah.
Mr. King? Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Griffin? Mr. Marino? Mr. Gowdy? Mr. Ross? Ms. Adams? Mr. Quayle? Mr. Amade? Mr. Conyers? Mr. Berman? Mr. Nadler? Mr. Scott? Mr. Watt? Ms. Lofgren? Ms. Jackson-Lee? Ms. Waters? Mr. Cohen? Mr. Johnson? Mr. Pierluisi? Mr. Quigley? Ms. Chu? Mr. Deutsch? Ms. Sanchez? Mr. Polis?
The gentleman from North Carolina. Gentleman from California. Gentleman from California, Mr. Isaac.
Okay, you're good.
I'm using this.
Why don't you sit here for the time being? Gentleman from Ohio. Gentleman from Ohio. Good. Very, very today.
I'm okay.
Gentleman from Florida. Do we have enough people for
Yeah, I think we'll have to have. We're not reporting anything, so we don't.
Okay. Gentleman from California, Mr. Berman. Present. We'll get started. The gentleman from Virginia and the gentleman from Georgia. And the gentleman from Florida, Mr. Deutsch. The clerk will report.
Mr. Chairman, 20 members responded present.
Okay. Working quorum is present, and we will proceed. I do have a couple of announcements first for members of the committee. The first is that if you are not aware of it, we have a friend.
Mr. Chairman, we can't hear you well down on this end.
Okay. We'll look for an upgrade in the sound system. Okay. A couple of announcements for the benefit of members of the committee and perhaps the audience as well. Our friend and colleague Howard Coble has been admitted to the George Washington Hospital with a respiratory illness. We expect him to be out in a few days. I talked to him yesterday, and he sounds very hale and hearty. We will miss Howard today, and actually many of us will miss his votes as well. As far as this markup goes, it is not likely to be one of our shortest markups. And so I encourage members to bring their lunch and a flashlight. We will probably go late tonight and go tomorrow as well. I know there are strong feelings about the legislation we're going to be considering today. There's obviously bipartisan support as well as bipartisan opposition. But I hope we will all remember we are among judiciary friends. Also, before we go on, I'd like to single out 3 staff members who've been working night and day on this legislation literally for most of this week. Sean McLaughlin, our chief counsel, David Whitney, who is to my right, and Vishal Amin as well, and appreciate their work. Pursuant to notice, I now call up H.R. 3261 for purposes of markup, and the clerk will report the bill.
H.R. 3261, to promote prosperity, creativity, entrepreneurship, and innovation by combating the theft of U.S. property.
Without objection, the bill is considered as read. I now recognize myself to offer an amendment in the nature of a substitute, and the clerk will report that amendment.
Amendment in the nature of a substitute to H.R. 3261, offered by Mr. Smith of Texas.
Without objection, the amendment.
I object.
An objection is heard, and the clerk will read the substitute amendment. If you'll proceed.
Strike all after the enacting clause and insert the following. Section 1, short title, table of contents. A, short title, this act may be cited as the Stop Online Piracy Act. B, table of contents. The table of contents of this act is as follows. Section 1, short title, table of contents. Section 2, savings and severability clauses. Title 1, combating online piracy. Section 101, definitions. Section 102, action by Attorney General to protect U.S. customers and prevent U.S. support of foreign infringing sites. Section 103, protection of U.S. customers and prevention of U.S. funding of sites dedicated to theft of U.S. property. Section 104, effective orders served on third-party entities. Section 105, actions taken consistent with the purposes of this title. Section 106, guidelines and study. Title 2, additional enhancements to combat intellectual property theft. Section 201, streaming of copyrighted works in violation of criminal law. Section 202, trafficking in inherently dangerous goods or services. Section 203, protecting U.S. businesses from foreign and economic espionage. Section 204, denying U.S. capital to notorious foreign infringers. Section 205, defending intellectual property rights abroad. Section 2, savings and severability clauses. A, savings clauses. 1, First Amendment. Nothing in this act shall be construed to impose a prior restraint on free speech or the press protected under the First Amendment to the Constitution. 2, Title 17 liability. Nothing in Title I shall be construed to enlarge or diminish liability, including vicarious or contributory liability, for any cause of action available under the Lanham Act or Title 17 United States Code, including any limitations on liability under such title, nor shall awareness of, receipt of, or response to any notice provided under Section 102B or 103B, or any order issued or served under Section 102 or 103, serve as a basis for determining eligibility for a limitation on liability under Section 512 of Title 17 United States Code. 3, no duty to monitor. Nothing in Title I shall be construed to impose a duty to monitor activity on the network or service of an entity described in Section 102C or 103C.
Mr. Chairman.
The gentleman from Virginia, Mr. Goodlatte.
Mr. Chairman, I ask unanimous consent that the reading of the manager's amendment.
I object.
Why?
Reserving the right to object, if I may.
I said why?
Does the gentlewoman from California wish to be recognized?
I would reserve the right to object, and I will explain why I, in fact, do object. In the past, members of this committee on both sides of the aisle have required the reading of bills and amendments because they were unhappy or mad, and that's not the case in this instance. I'm mindful, however, that this amendment was distributed for the very first time Monday night. In fact, my staff pulled an all-nighter in order to put together amendments by the 10 a.m. deadline. The public doesn't even know, in many cases, what's in this amendment. We had a hearing a month ago. We haven't even received the answers to the questions that we were permitted to submit. We've had one hearing, and at that hearing there was only one witness permitted to testify in opposition to the measure. We've had no subcommittee markups, and I think just in the interest of transparency for the public, we ought to have an airing of what is in this manager's amendment. I understand that it's not a pleasure since we have read it, I have read it, but I think for the public's sake, it is necessary. I'm mindful in the 90s, when I was a member of this committee, when we fomented the DMCA, we spent years, I mean, hundreds of hours working on this measure. This is being jammed through in 2 months' time. So I do object to waiving the reading of the amendment.
Could the gentlelady yield?
I would be happy to yield.
Thank you. Well, we're happy to learn that you're not mad or unhappy. That's a relief, because we could have
I remember Phil Burton's advice, be happy in your work.
All right. Now that we got that much out of the way, is the gentlelady suggesting, because there were no subcommittee markup, that there ought to be a postponement of this hearing today and that we come back and look at it later?
I think that would be a preferable approach, frankly. But as I am not the chair of the committee, that is not, it is not my opportunity to set the schedule. All I can do is object to waiving the reading of the...
Would the gentlelady yield?
I would be happy to yield to my...
I thank the gentlelady, and I join with her in expressing that the manager's amendment is, in fact, so substantially different, and I applaud the chairman for making some of the changes that I think in such a short period of time became recognized. But only an hour ago, KeepTheWebOpen.com published SOPA for the first time so that the public could begin looking at it in an interactive way. There are 60 or more amendments that will be offered here over the next 2+ days. Those amendments should go on the web, they should be understood, and we should have a hearing on the basis of the now new proposed legislation and many of the amendments that would substantially improve the bill. If we did that, if we allowed, if you will, the Christmas season to allow for this kind of airing, held a hearing with technical experts, including, for example, Secretary of Napolitano's own brother from Sandia Lab, who made it clear that the current bill does not have technology that would effectively provide DNS blocking. And, oh, by the way, the new bill, only safe haven is still that same DNS blocking. That's just one of many examples. So I join with the gentlelady that I believe we need to slow down and give not just the public, but the technology public, the vast technology public that will be impacted by this, an opportunity. I, for one, would make sure that every one of my amendments and every amendment I have any control over were made equally public at keepthewebopen.com, so that we could begin evaluating how to get to the right solution to protect against piracy, which is the one thing on both sides of and both rows of the dais we agree on. I thank the gentlelady.
Does the gentleman from California yield back her time?
Yes, and I object to the waiving of the reading.
Okay. The gentleman from California continues to object. Let me just mention to members, or remind members, that the manager's amendment was actually posted online Monday night, many hours before we were required to post it Tuesday morning. Also, this committee this year has adopted the practice of asking for amendments ahead of time from members, and as a result, the public does have more time than they often are used to getting with other committees to review the amendments. Lastly, while I wish we were not reading the manager's amendment, a case can be made to read the manager's amendment, since on the basis of the statements of some of those in opposition, and I'm not referring to any Judiciary Committee member, it's clear that they have not read the manager's amendment and don't appreciate what's in the manager's amendment, so maybe they will be so enlightened. That said, let me say to members that we anticipate that the reading of the manager's amendment will take 45 minutes to an hour, and if the objection is continued, we will not be moving on to the opening statements until after that period of time. And the clerk will continue to read the manager's amendment.
4. No technology mandates. Nothing in Title I shall be construed to impose a duty on an entity described in Section 102C or 103C to design its network, technology, or service to forestall or prevent acts that would actually or potentially create a cause of action under such title, or to utilize any particular type of technology to comply with the requirements of such title. 5. No impact on security or integrity. Nothing in Title I shall be construed to authorize a court to require compliance with an obligation under Section 102C in a manner that would impair the security or integrity of the domain name system or of the system or network operated by or on behalf of the party subject to the obligation. B. Severability. If any provision of this Act or the application of the provision to any person or circumstance is held to be unconstitutional, the other provisions or the application of the provision to other persons or circumstances shall not be affected thereby. C. Definitions. The terms used in this section have the meanings given those terms in Section 101. Title I. Combating Online Piracy. Section 101. Definitions. In this title, 1. Domain name. The term domain name has the meaning given that term in Section 45 of the Lanham Act, 15 U.S. Code 1127. 2. Domain name system server. The term domain name system server means a server or other mechanism used to provide the Internet protocol address associated with a domain name. 3. Domestic domain name. The term domestic domain name means a domain name that is registered or assigned by a domain name registrar, domain name registry, or other domain name registration authority that is located within a judicial district of the United States. 4. Domestic Internet Protocol Address. The term domestic Internet Protocol Address means an Internet Protocol address for which the corresponding Internet Protocol allocation entity and the entity using the Internet Protocol address are located within a judicial district of the United States. 5. Domestic Internet Site. The term domestic Internet Site means an Internet site for which the corresponding domain name or, if there is no domain name, the corresponding Internet Protocol address is a domestic domain name or domestic Internet Protocol address. 6. Foreign domain name. The term foreign domain name means a domain name that is not a domestic domain name. 7. Foreign Internet Protocol address. The term foreign Internet Protocol address means an Internet Protocol address that is not a domestic Internet Protocol address. 8. Foreign Internet Site. The term foreign Internet Site means an Internet site that is not a domestic site. 9. Intellectual Property Enforcement Coordinator. The term Intellectual Property Enforcement Coordinator means the Intellectual Property Enforcement Coordinator appointed under Section 301 of the Prioritizing Resources and Organization for Intellectual Property Act of 2008, 15 U.S.C. 8111. 10. Internet. The term Internet has the meaning given that term in Section 53625.
Point of parliamentary inquiry, Mr. Chairman.
The gentleman from California will state his parliamentary inquiry.
I have concluded that, notwithstanding the chairman's hope of people being enlightened, that those who have not been enlightened by the manager's amendment already have a form of internal blocking and redirection going on. And so I'm wondering if a motion to dispense with the reading is in order.
I am told that such a motion is regrettably not in order.
Okay, thank you.
Clerk will proceed.
Section 53625 of Title 31 United States Code. 11. Internet advertising service. The term Internet advertising service means a service that for compensation sells, purchases, brokers, serves, inserts, verifies, or clears the placement of an advertisement, including a paid or sponsored search result, link, or placement that is rendered in viewable form for any period of time on an Internet site. 12. Internet protocol. The term Internet protocol means a protocol used for communicating data across a packet-switched Internet network using the transmission control protocol / Internet protocol and includes any predecessor or successor protocol to such protocol. 13. Internet protocol address. The term Internet protocol address means numerical or hexadecimal label that is assigned to each device that participates in a computer network that uses the Internet protocol for communication. 14. Internet protocol allocation entity. The term Internet protocol allocation entity means the American Registry of Internet Numbers, ARIN, its successor, if any, or any Internet protocol Internet registry that is formally recognized by the United States government, from which an Internet protocol address is allocated or where it is registered. 15. Internet search engine. The term Internet search engine A means a service made available via the Internet whose primary function is gathering and reporting, in response to a user query, indexed information or websites available elsewhere on the Internet. And B does not include a service that retains a third party that is subject to service of process in the United States to gather, index, or report information available elsewhere on the Internet. 16. Internet site. The term Internet site means the collection of digital assets, including links, indexes, or pointers to digital assets accessible through the Internet that are addressed relative to a common domain name or, if there is no domain name, a common Internet protocol address. Except where otherwise provided in this title, the term Internet site may include a specifically identified portion of such site. 17. Lanham Act. The term Lanham Act means the act entitled An Act to Provide for the Registration and Protection of Trademarks Used in Commerce to carry out the provisions of certain international conventions and for other purposes. Approved July 5, 1946, commonly referred to as the Trademark Act of 1946 or the Lanham Act. 18. Non-authoritative domain name server. The term non-authoritative domain name server means a server that does not contain complete copies of domains but uses a cache file that is comprised of previous domain name server lookups for which the server has received an authoritative response in the past. 19. Operator. The term operator, when used in connection with an Internet site, includes any person with authority to operate such Internet site. 20. Payment network provider. A. In general, the term payment network provider means an entity that directly or indirectly provides the proprietary services, infrastructure, and software to effect or facilitate a debit, credit, or other payment transaction. B. Rule of construction. For purposes of this paragraph, a depository institution, as such term is defined under Section 3 of the Federal Deposit Insurance Act, or credit union, that acquires, authorizes, initiates, or receives a debit, credit, or other payment transaction shall not be construed to be a payment network provider based solely on the offering of services described in the subparagraph. 21. Service provider. The term service provider, A, means an operator of a non-authoritative domain name server, and B, does not include an operator of a non-authoritative domain name server that offers domain name resolution services solely to businesses for domain, subdomain, domain name, system record, or Internet protocol address management. 22. State. The term state includes the District of Columbia and any Commonwealth, territory, or possession of the United States. 23. U.S.-directed site. The term U.S.-directed site means a foreign Internet site that is used to conduct business directed to residents of the United States, or that otherwise demonstrates the existence of minimum contacts sufficient for the exercise of personal jurisdiction over the owner or operator of the Internet site, consistent with the Constitution of the United States. Based on relevant evidence that may include whether A, the Internet site is used to provide goods or services to users located in the United States, B, there is evidence that the Internet site is intended to offer or provide 1, such goods and services, 2, access to such goods or services, or 3, delivery of such goods and services to users located in the United States, and C, any prices for goods and services are indicated or billed in the currency of the United States. 24. United States. The term United States includes any Commonwealth, possession, or territory of the United States. Section 102. Action by Attorney General to protect U.S. customers and prevent U.S. support of foreign infringing sites. A. Definition. For purposes of this section, a foreign Internet site is a foreign infringing site if 1. The Internet site is a U.S.-directed site and is used by users in the United States. And 2, the Internet site is being operated in a manner that would, if it were a domestic Internet site, subject it or its associated domain name to A, seizure or forfeiture in the United States in an action brought by the Attorney General by reason of an act prohibited by Section 2318, 2319, 2319A, 2319B, or 2320, or Chapter 90 of Title 18 United States Code, or B, prosecution by the Attorney General under Section 1204 of Title 17 United States Code by reason of a violation of Section 1201 of such title. B, action by the Attorney General. 1. In personam. The Attorney General may commence an in personam action against A registrant of a domain name used by a foreign infringing site, or B, an owner or operator of a foreign infringing site. 2. In rem. If through due diligence the Attorney General is unable to find any person described in subparagraph A or B of paragraph 1 with respect to a foreign infringing site, or no such person found has an address within a judicial district of the United States, the Attorney General may commence an in rem action against that foreign infringing site or the foreign domain name used by such site. 3. Notice. Upon commencing an action under this subsection, the Attorney General shall send a notice of the alleged activity described in subparagraph A or B of subsection A2 and intent to proceed under this section. A1. To all registrants, if any, of the domain name of the Internet site, 1. At the postal and electronic mail addresses of each such registrant appearing in the applicable publicly accessible database of registrations, if any, and to the extent such addresses are reasonably available, and 2. Via the postal and electronic mail addresses of the registrar, registry, or other domain name registration authority that registered or assigned the domain name of the Internet site to the extent such addresses are reasonably available. And 2. To all owners and operators, if any, of the Internet site known to the Attorney General at the time the action is commenced. 1. At the primary postal and electronic mail addresses, if any, for each such owner or operator that are provided on the Internet site to the extent such addresses are reasonably available. Or 2. If there is no domain name of the Internet site, via the postal and electronic mail addresses, if any, of the service provider responsible for allocating the Internet protocol address to the Internet site, as found in the applicable publicly accessible database of allocations and assignments of Internet protocol addresses to service providers, to the extent such postal and electronic mail addresses are reasonably available. Or B, in any other such form as the Court may provide, including as may be required by Rule 4F of the Federal Rules of Civil Procedure. 4. Service of process. For purposes of this section, the actions described in this subsection shall constitute service of process. 5. Relief. On application of the Attorney General following the commencement of an action under this section, the Court may issue a temporary restraining order, a preliminary injunction, or an injunction in accordance with Rule 65 of the Federal Rules of Civil Procedure against a registrant of a domain name used by the foreign infringing site or an owner or operator of the foreign infringing site, or in an action brought in rem under paragraph 2 against the foreign infringing site or the domain name used by such site to cease and desist from undertaking any further action as a foreign infringing site. C. Actions based on court orders. 1. Service. A process server on behalf of the Attorney General, with prior approval of the Court, may serve a copy of a court order issued under subsection B on similarly situated entities with each class described in paragraph 2. Proof of service shall be filed with the Court. 2. Reasonable measures. After being served with a copy of an order under paragraph 1, the following shall apply, subject to sections 2 and 104 of this Act. Service providers. 1. In general, a service provider shall take such measures as it determines to be the least burdensome, technically feasible, and reasonable means designed to prevent access by its subscribers located within the United States to the foreign infringing site that is subject to the order. Such action shall be taken as expeditiously as possible. 2. Safe harbor. The measures determined by a service provider to be the least burdensome, technically feasible, and reasonable means designed to prevent a non-authoritative domain name system server under the direct control of the service provider from resolving the domain name of the forward infringing site to that domain name's Internet protocol address shall fully satisfy such service provider's obligation described in Clause 1. An order issued under this section may not impose any additional obligations on or require additional actions by a service provider. 3. Limitations. A service provider shall not be required under this subsection 1, except as necessary to comply with this subparagraph, to modify its network, software, systems, or facilities. 2. To take any measures with respect to domain name resolutions not performed by its own domain name server. 3. To continue to prevent access to a domain name to which access has been effectively disabled by other means. 4. To prevent access to a subdomain or to any portion of an Internet site other than as the result of an order to prevent access to the domain name or to the entire Internet site of which it is a part. Or 5, to direct or redirect users via domain name resolution to an Internet site other than the foreign infringing site requested by the user. 4. Construction. Nothing in this subparagraph shall affect the limitation on the liability of a service provider under Section 512 of Title 17 United States Code. B. Internet search engines. A provider of an Internet search engine shall take technically feasible and commercially reasonable measures as expeditiously as possible designed to prevent the serving, in response to a query, of a direct hypertext link to the foreign infringing site that is subject to the order, or the portion of such site specified in the order. The court order under this subsection that applies to an Internet search engine should be narrowly tailored by the court, consistent with the First Amendment to the Constitution, to be the least restrictive means to effectively achieve the goals of this title. C. Payment network providers. 1. Preventing affiliation. A payment network provider shall take technically feasible and commercially reasonable measures as expeditiously as possible, designed to prevent, prohibit, or suspend its service from completing payment transactions involving customers located within the United States or accounts originating in the United States and the payment account, 1. that is used by the foreign infringing site that is subject to the order, and 2. through which payment transactions processed by the payment network provider will be completed. 2. Application. A payment network provider shall be considered to be in compliance with Clause 1 if it takes action described in that clause with respect to the payment account that is used by the foreign infringing site subject to the order as of the date on which a copy of the order is served under paragraph 1, or as of the date on which a copy of the order as modified under subsection D or as amended under subsection E is served under subsection F, whichever dates apply. Internet advertising services. 1. Required actions. An Internet advertising service that contracts to provide advertising to or for the foreign infringing site that is subject to the order, or that knowingly serves advertising to or for such site, shall take technically feasible and commercially reasonable measures as expeditiously as possible designed to 1. Prevent its service from providing advertisements to or relating to the foreign infringing site that is specified in the order. 2. Cease making available advertisements for the foreign infringing site or paid or sponsored search results, links, or other placements that provide access to the foreign infringing site. And 3, cease providing or receiving any compensation for advertising or related services to, from, or in connection with the foreign infringing site. 2, application. An Internet advertising service shall be considered to be in compliance with Clause 1 if it takes action described in that clause with respect to advertising provided to or for the foreign infringing site as of the date on which a copy of the order is served under paragraph 1, or as of the date on which a copy of the order as modified under subsection D or as amended under subsection E is served under subsection F, whichever dates apply. 3, enforcement of orders. A, in general, to ensure compliance with orders issued under this section, the Attorney General may bring an action for injunctive relief, 1, against any entity served under paragraph 1 that knowingly and willfully fails to comply with the requirements of this subsection to compel such entity to comply with such requirements, or 2, against any entity that knowingly and willfully provides or offers to provide a product or service designed or marketed by such entity or by other, in concert with such entity for the circumvention or bypassing of measures described in paragraph 2 and taken in response to a court order issued under this subsection, to enjoin such entity from interfering with the order by continuing to provide or offer to provide such product or service. B, rule of construction. The authority granted the Attorney General under subparagraph A1 shall be the sole legal remedy to enforce the obligations under this section of any entity described in paragraph 2. C, defense. A defendant in an action under subparagraph A1 may establish an affirmative defense by showing that the defendant does not have the technical means to comply with the subsection without incurring an unreasonable economic burden, or that the court order issued under subsection B is not authorized by this section. Such showing shall not be presumed to be a complete defense, but shall serve as a defense only for those measures for which a technical limitation on compliance is demonstrated or for such portions of the order as are demonstrated to be unauthorized by this section. D, definition. For purposes of this subparagraph A1, a product or service designed or marketed for the circumvention or bypassing of measures described in paragraph 2 and taken in response to a court order issued under subsection B includes a product or service that is designed or marketed for the purpose of enabling a domain name described in such an order. 1, to resolve to that domain name's Internet protocol address, notwithstanding the measures taken by a service provider under paragraph 2 to prevent such resolution, or 2, to resolve to a different domain name or Internet protocol address that the provider of the product or service knows, reasonably should know, or reasonably believes is used by an Internet site offering substantially similar infringing activities as those with which the foreign infringing site that is subject to the court order was associated. D, modification or verification of orders. 1, in general, at any time after the issuance of an order under subsection B, a motion to modify, suspend, or vacate the order may be filed by A, any person or owner or operator of property that is subject to the order, B, any registrant of the domain name or the owner or operator of the Internet site that is subject to the order, C, any domain name registrar, registry, or other domain name registration authority that has registered or assigned the domain name of the Internet site that is subject to the order, D, any entity that has been served with a copy of an order under subsection C that requires such entity to take action prescribed in that subsection, or E, the Attorney General. 2, relief. Relief under this subsection shall be proper if the court finds that A, the foreign Internet site subject to the order was improvidently adjudicated or is no longer a foreign infringing site. B, compliance with the order, unless modified, would impair the security or integrity of the domain name system or of the system or network operated by or on behalf of the parties subject to subsection C2, or C, the interests of justice otherwise require that the order be modified, suspended, or vacated. 3. Consideration. In making a relief determination under paragraph 2, a court may consider whether the domain name of the foreign internet site has expired or has been re-registered by an entity other than the entity that is subject to the order with respect to which the motion under paragraph 1 is brought. 4. Intervention. An entity required to take action under subsection C if an order issues under subsection B may intervene at any time in any action commenced under subsection B that may result in such order, or in any action to modify, suspend, or vacate such order under this subsection. E. Amended orders. The Attorney General, if alleging that a foreign internet site previously adjudicated in an action under this section to be a foreign infringing site is accessible or has been reconstituted at a different domain name or internet protocol address, may petition the court to amend the order issued under this section accordingly. F. Service of an action based on modified, suspended, vacated, or amended orders. 1. Service requirement. The Attorney General shall serve any entity that has been served with a copy of an order under subsection C with a copy of any modification, suspension, or vacation of, or amendment to that order under subsection D or E. 2. Action subsequent to service. An entity that is served with a copy of a modified, suspended, or amended order under paragraph 1 shall take actions consistent with subsection C2 in accordance with the modification, suspension, or amendment. An entity that is served with a copy of a vacated order under paragraph 1 may restore any services that were provided before being served with a copy of the order under subsection C. G. Law enforcement coordination. 1. In general, the Attorney General shall inform the Intellectual Property Enforcement Coordinator and the heads of appropriate law enforcement agencies of all court orders issued under subsection B and all amended orders issued under subsection E regarding foreign infringing sites. 2. Alterations. The Attorney General shall, and the defendant may, inform the Intellectual Property Enforcement Coordinator of the modification, suspension, expiration, or vacation under subsection D of a court order issued under subsection B. Section 103, Protection of U.S. Customers and Prevention of U.S. Funding of Sites Dedicated to Theft of U.S. Property. A. Definitions. In this section, 1. Dedicated to theft of U.S. property. An Internet site is an Internet site dedicated to the theft of U.S. property if A. It is 1. A U.S.-directed site, or 2. An Internet site for which the registrant of the domain name used by the Internet site and the owner or operator of the Internet site are not located and cannot be found within the United States. B. The site is used by users in the United States. And C. Either 1. The site is primarily designed or operated for the purpose of, has only limited purpose or use other than, or is marketed by its operator or another acting in concert with that operator, primarily for use in offering goods or service in violation of 1. Section 501, Title 17, United States Code, for purposes of commercial advantage or private financial gain, and with respect to infringement of complete or substantially complete works. 2. Section 1201 of Title 17 United States Code, or 3. Provisions of the Lanham Act that prohibit the sale, distribution, or promotion of goods, services, or materials bearing a counterfeit mark, as that term is defined in Section 34D of the Lanham Act, 15 U.S. Code 116D, or Section 2320 of Title 18 United States Code. 2. The operator of the site operates the site with the object of promoting or has promoted its use to carry out acts that constitute a violation of Section 501 or 1201 of Title 17 United States Code, as shown by clear expression or other affirmative steps taken to foster such violation. 2. Qualifying plaintiff. The term qualifying plaintiff means, with respect to a particular Internet site, a person withstanding to bring a civil action for a violation described in paragraph 1C. B. Limited injunctive relief. 1. In personam. A qualifying plaintiff may commence an in personam action against A. A registrant of a domain name used by an Internet site dedicated to theft of U.S. property, or B. An owner or operator of that Internet site. 2. In rem. If through due diligence a qualifying plaintiff who is authorized to bring an in personam action against paragraph 1 with respect to an Internet site dedicated to theft of U.S. property is unable to find a person described in subparagraphs A or B of paragraph 1, or no such person has found an address with a judicial district of the United States, the qualifying plaintiff may commence an in rem action against the Internet site or the domain name used by that Internet site. 3. Notice. Upon commencing an action under this subsection, the qualifying plaintiff shall send a notice of the alleged activity described in subsection A1C and intent to proceed under the subsection. A1. To all registrants, if any, of the domain name of the Internet site. 1. At the postal and electronic mail addresses, if any, of each such registrant appearing in the applicable publicly accessible database of registrations, if any, and to the extent such addresses are reasonably available. And 2, via the postal and electronic mail addresses of the registrar, registry, or other domain name registration authority that registered or assigned the domain name of the Internet site or portion thereof, to the extent such addresses are reasonably available. And 2, all owners and operators of the Internet site known to the qualifying plaintiff at the time the action is commenced, if any. 1. At the primary postal and electronic mail addresses, if any, for each such owner and operator that are provided on the Internet site, and to the extent such addresses are reasonably available. Or 2. If there is no domain name of the Internet site, via the postal and electronic mail addresses, if any, of the service provider reasonable responsible for allocating the Internet Protocol address to the Internet site, as found in the applicable publicly accessible database of allocations and assignments of Internet Protocol addresses to service providers, to the extent such postal and electronic mail addresses are reasonably available, or B, in any other such form as the Court may prescribe, including as may be required by Rule 4F of the Federal Rules of Civil Procedure. 4. Service of process. For purposes of this section, the actions described in the subsection shall constitute service of process. 5. Relief. On an application of a qualifying plaintiff following the commencement of an action under this section with respect to an Internet site dedicated to the theft of U.S. property, the Court may issue a temporary restraining order, a preliminary injunction, or an injunction in accordance with Rule 65 of the Federal Rules of Civil Procedure against a registrant of a domain name used by the Internet site or against an owner or operator of the Internet site, or in an action brought in rem under paragraph 2 against the Internet site or against the domain name used by the Internet site to cease and desist from undertaking any further activity as an Internet site dedicated to the theft of U.S. property. C. Actions based on court orders. 1. Service by qualifying plaintiff. A qualifying plaintiff, with the prior approval of the Court, may serve a copy of a court order issued under subsection C on similarly situated entities described in paragraph 2. Proof of service shall be filed with the Court. 2. Reasonable measures. After being served with a copy of an order under the subsection, the following shall apply, subject to sections 2 and 104 of this Act. A. Payment network providers. 1. Preventing affiliation. A payment network provider shall take technically feasible and commercially reasonable measures as expeditiously as possible that are designed to prevent, prohibit, or suspend its service from completing payment transactions involving customers located within the United States or accounts originating in the United States and the payment account. 1. That is used by the Internet site dedicated to the theft of U.S. property that is subject to the order, and 2. Through which payment transactions processed by the payment network provider would be completed. 2. Application. A payment network provider shall be considered to be in compliance with Clause 1 if it takes action described in that clause with respect to the payment account that is used by the Internet site dedicated to the theft of U.S. property that is subject to the order as of the date on which a copy of the order is served under paragraph 1, or as of the date on which a copy of the order as modified under subsection E or as amended under subsection F is served under subsection G, whichever dates apply. B. Internet advertising services. 1. Required actions. An Internet advertising service that contracts with the Internet site dedicated to the theft of U.S. property that is subject to the order to provide advertising to or for such Internet site, or that knowingly serves advertising to or for such Internet site, shall take technically feasible and commercially reasonable measures as expeditiously as possible that are designed to 1. Prevent its service from providing advertisements to or relating to the Internet site. 2. Cease making available advertisements for the Internet site, or paid or sponsored search results, links, or other placements that provide access to the Internet site. And 3, cease providing or receiving any compensation for advertising or related services to, from, or in connection with the Internet site. 2, application. An Internet advertising service shall be considered to be in compliance with Clause 1 if it takes action described in that clause with respect to advertising provided to or for the Internet site dedicated to the theft of U.S. property as of the date on which a copy of the order is served under paragraph 1. Or as of the date on which a copy of the order as modified under subsection D or as amended under subsection F or as amended under subsection E is served under subsection F, whichever dates apply. 3. Enforcement of orders. A. Rule of construction. The procedures and relief provided under this subsection shall be the sole legal remedy to enforce the obligations of any entity under this subsection. B. Procedures and relief. 1. Procedure. Upon the filing of a claim and a showing by the qualifying plaintiff that an entity served with a copy of the court order issued under subsection C has not made good faith efforts to comply with its obligations under this subsection by reason of such court order, the court shall require the entity to show cause why an order should not issue to require compliance with the obligations of the subsection. The claim and showing under this clause shall be filed with the court that issued the court order, or if that court lacks jurisdiction over the entity, with any court that has jurisdiction over that entity. 2. Service of process. The qualifying plaintiff shall serve on the entity process of filing the claim in the order to show cause. Such process and order may be served in any judicial district where the entity resides or may be found. 3. Authority of court. Upon consideration of the evidence presented by all parties in connection with the order to show cause, the court is authorized, in addition to an order to require compliance with its obligations of the subsection, to impose a remedy consistent with the court's exercise of its equitable authority to enforce compliance with its lawful orders if the entity has knowingly and willfully failed to so comply. C. Defense. An entity against whom relief is sought under subparagraph B may establish an affirmative defense by showing that the entity does not have the technical means to comply with this subsection without incurring an unreasonable economic burden, or that the order is not authorized by this subsection. Such showing shall not be presumed to be complete defense, but shall serve as a defense only for those measures for which a technical limitation on compliance is demonstrated, or for such parts of the order as are demonstrated to be unauthorized by this section. D. Modification or vacation of orders. 1. In general, at any time after the issuance of an order under subsection C or an amended order issued under subsection E with respect to an Internet site dedicated to the theft of U.S. property, a motion to modify, suspend, or vacate the order may be filed by A. Any person or owner or operator of property that is subject to the order, B. Any registrant of the domain name or the owner or operator of such Internet site, C. Any domain name registrar, registry, or other domain name registration authority that has registered or assigned the domain name of such Internet site, or D, any entity that has been served with a copy of an order under subsection C or an amended order under subsection E that requires such entity to take action prescribed in that subsection. 2, relief. Relief under the subsection shall be proper if the court finds that A, the Internet site subject to the order was improvidently adjudicated or is no longer an Internet site dedicated to the theft of U.S. property, or B, the interest of justice otherwise required that the order be modified, suspended, or vacated. 3, consideration. In making a relief determination under paragraph 2, a court may consider whether the domain name of the Internet site has expired or has been re-registered by an entity other than the entity that is subject to the order with respect to which the motion under paragraph 1 is brought. 4, intervention. An entity required to take action under subsection D if an order issues under subsection C may intervene at any time in any action commenced under subsection C that may result in such order, or in any action to modify, suspend, or vacate such order under the subsection. E, amended orders. The qualifying plaintiff, if alleging that an Internet site previously adjudicated in an action under this section to be an Internet site dedicated to the theft of U.S. property is accessible or has been reconstituted at a different domain name or Internet protocol address, may petition the court to amend the order issued under this section accordingly. F, service of an action based on modified, suspended, vacated, or amended orders. 1, service requirement. The qualifying plaintiff shall serve any entity that has been served with a copy of an order under subsection C with a copy of any modification, suspension, or vacation of or amendment to that order under subsection D or E. 2, action subsequent to service. An entity that is served with a copy of a modified, suspended, or amended order with paragraph 1 shall take actions consistent with subsection C2 in accordance with the modification, suspension, or amendment. An entity that is served with a copy of a vacated order under paragraph 1 may restore any services that were provided before being served with a copy of the order under subsection C. F, reporting of orders. 1, in general, the qualifying plaintiff shall inform the intellectual property enforcement coordinator of any court order issued under subsection C or amended order issued under subsection E. 2, alterations. Upon the modification, suspension, expiration, or vacation under subsection D of a court order issued under subsection C, the qualifying plaintiff shall and the defendant may so inform the intellectual property enforcement coordinator. Section 104, effective orders served on third-party entities. A, relief limited to scope of violation. In any case in which only a specifically identified portion of an Internet site is identified by the court as a foreign infringing site or as an Internet site dedicated to the theft of U.S. property, made subject to an order under subsection 102B5 or 103B5, the relief granted under such subsection and the obligations of any entity served with a copy of an order under section 102C or 103C shall be confined to that specified portion so identified and made subject to the order. Nothing in the order shall be interpreted to impose obligations on any entity served with a copy of the order with respect to any other portion of an Internet site not specified in the order. B, limitations relating to court orders. 1, applicability. This subsection applies to liability or evidence in any claim or cause of action under federal or state law other than an enforcement action under section 102C3 or 103C3 against an entity served with a copy of an order under sections 102C or 103C, any entity described in section 101(20)B, or any director, officer, employee, or agent of any such entity. 2, limit on liability of entities. Subject to paragraph 1, any entity served with a copy of an order under sections 102C or 103C, any entity described in sections 101(20)B, and any director, officer, employee, or agent of any such entity shall not be liable for any acts reasonably designed to comply with such order or reasonably arising from such order, and no cause of action shall lie in any federal or state court or administrative agency against such an entity or director, office, employee, or agent thereof for such an act. 3, acts of circumvention by customers. Subject to paragraph 1, any entity served with a copy of an order under sections 102C or 103C, any entity described in section 101(20)B, and any director, officer, employee, or agent of any such entity shall not be liable for any actions taken by customers of any such entity to circumvent any measure implemented in good faith by the entity in order to comply with that order. Section 105, actions taken consistent with the purposes of this title. A, in general, no cause of action shall lie in any federal or state court or administrative agency against. No person may rely in any claim or cause of action against, and no liability for damages to any person shall be granted against a service provider, payment network provider, internet advertising service, advertiser, internet search engine, domain name registry, domain name registrar, entity described in section 101(20)B, or internet protocol allocation entity, including any director, officers, employees, or agents of any such entity, only for taking the actions described in section 102C2 or section 103C2. With respect to an Internet site, acting in good faith and based on credible evidence that 1, the Internet site is a foreign infringing site, is an Internet site dedicated to the theft of U.S. property, or is an Internet site that endangers the public health. And 2, the action is narrowly tailored and consistent with the entity's terms of service or other contractual rights and with the purposes of this title. C, definitions. In this section, 1, adulterated. The term adulterated has the meaning given that term in section 501 of the Federal Food, Drug, and Cosmetic Act, 21 U.S. Code 351. 2, Internet site that endangers the public health. The term internet site that endangers the public health means an internet site that is primarily designed or operated for the purpose of, has only limited purpose or use other than, or is marketed by its operator or another acting in concert with that operator primarily for use in A, offering, selling, dispensing, or distributing any prescription medication and does so regularly without a valid prescription, or B, offering, selling, dispensing, or distributing any prescription medication that is adulterated or misbranded. 3, misbranded. The term misbranded has the meaning given that term in Section 502 of the Federal Food, Drug, and Cosmetic Act, 21 U.S. Code 352. Prescription medication. A, prescription medication. The term prescription medication means a drug that is subject to Section 503B of the Federal Food, Drug, and Cosmetic Act, 21 U.S. Code 353B. B, drug. The term drug has the meaning given that term in Section 201G1 of the Federal Food, Drug, and Cosmetic Act, 21 U.S. Code 321G1. 5, valid prescription. The term valid prescription has the meaning given that term in Section 309E2A of the Controlled Substances Act, 21 U.S. Code 829E2A. Section 106, Guidelines and Study. A, Guidelines. The Attorney General shall, 1, provide appropriate resources and procedures for case management and development to effect timely disposition of actions brought under this title. 2, develop a deconfliction process in consultation with appropriate law enforcement agencies, including U.S. Immigration and Customs Enforcement, to coordinate enforcement activities under this title. 3, publish procedures developed in consultation with appropriate law enforcement agencies, including U.S. Immigration and Customs Enforcement, to receive information from the public relevant to the enforcement of this title. 4, provide guidance to intellectual property rights holders about what information such rights holders should provide to assist in initiating an investigation or to supplement an ongoing investigation under this title. And 5, develop and make available to entities served with a copy of an order under Section 102C or 103C and such others as the Attorney General determines is appropriate, a form of notice that includes information regarding the reasons for and impact on users of orders issued under Sections 102 and 103 for use by and at the sole discretion of entities receiving it. B, study. 1, by the Register of Copyrights. A, nature of study. The Register of Copyrights, in consultation with appropriate departments and agencies of the United States and other stakeholders, shall conduct a study on the enforcement and effectiveness of this title and on any need to amend the provisions of this title to adapt to emerging technologies. B, reports to Congress. Not later than 2 years after the date of the enactment of this Act, the Register of Copyrights shall subject to the Committees on the Judiciary of the House of Representatives and the Senate a report containing the results of the study conducted under this subsection and any recommendations that the Register may have as a result of the study. 2, report on effectiveness of certain measures. Not later than 1 year after the date of enactment of this Act, the Secretary of Commerce, in coordination with the Attorney General, the Secretary of Homeland Security, the Register of Copyrights, and the Intellectual Property Enforcement Coordinator, shall conduct a study and report to the Committee on the Judiciary of the Senate and the Committee on the Judiciary of the House of Representatives on the following. 1, an assessment of the effects, if any, of the implementation of Section 102C2A on the accessibility of Internet sites dedicated to infringing activity. B, an assessment of the effects, if any, of the implementation of Section 102C2A on the deployment, security, and reliability of the domain name system and associated Internet processes, including domain name system security extensions. C, recommendations, if any, for modifying or amending this title to increase effectiveness or ameliorate any unintended effects of Section 102C2A. Title 2, additional enhancements to combat intellectual property theft. Section 201, streaming of copyrighted works in violation of criminal law. A, Title 17 amendments. Section 506A of Title 17 United States Code is amended to read as follows. A, criminal infringement. 1, in general, any person who willfully infringes a copyright shall be punished as provided under Section 2319 of Title 18 if the infringement was committed, A, for purposes of commercial advantage or private financial gain, B, by the reproduction or distribution, including by electronic means, during any 180-day period of one or more copies of phonorecords of one or more copyrighted works, or by the public performance by means of digital transmission during any 180-day period of one or more copyrighted works when the total retail value of the copies or phonorecords or of the public performances is more than $1,000, or C, by the distribution or public performance of a work being prepared for commercial dissemination by making it available on a computer network accessible to members of the public if such person knew or should have known that the work was intended for commercial dissemination. 2, evidence. For purposes of this subsection, evidence of reproduction, distribution, or public performance of a copyrighted work by itself shall not be sufficient to establish willful infringement of a copyright. 3, definition. In this subsection, the term work being prepared for commercial dissemination means A, computer program, a musical work, a motion picture, or other audiovisual work, a literary work, or a sound recording, if at the time of unauthorized distribution or public performance, 1, the copyright owner has a reasonable expectation of commercial distribution, and 2, the copies or phonorecords of the work have not been commercially distributed in the United States by or with authorization of the copyright owner, or 2, 1, the copyright owner does not intend to offer copies of the work for commercial distribution but has a reasonable expectation of other forms of commercial dissemination of the work. And 2, the work has not been commercially disseminated to the public in the United States by or with the authorization of the copyright owner. B, a motion picture, if at the time of unauthorized distribution or public performance, the motion picture, 1, has been made available for viewing in a motion picture exhibition facility, and 2, has not been made available in copies for sale to the general public in the United States by or with the authorization of the copyright owner in a format intended to permit viewing outside a motion picture exhibition facility, or 2, had not been commercially disseminated to the public in the United States by or with authorization of the copyright owner more than 24 hours before the unauthorized distribution or public performance. The Title 18 Amendment, Section 2319 of Title 18 United States Code is amended. 1, in subsection A, by striking any person who and inserting whoever, by amending subsections 2, by amending subsections B, C, and D to read as follows. B, whoever commits an offense under subsection 506A1A of Title 17, 1, shall be fined under this title in prison not more than 5 years or both if the offense consists of the reproduction or distribution, including by electronic means, of at least 10 copies or phonorecords, or of at least 10 public performances by means of digital transmission of one or more copyrighted works during any 180-day period which have a total retail value of more than $2,500. 2, shall be fined under this title in prison not more than 10 years or both if the offense is a felony and is a second or subsequent offense under subsection A, or 3, shall be fined under this title in prison not more than 1 year or both in any other case. C, whoever commits an offense under section 506A1B of Title 17, 1, shall be fined under this title in prison not more than 3 years or both if the offense consists of the reproduction or distribution, including by electronic means, of at least 10 copies or phonorecords, or of at least 10 public performances by means of digital transmission of one or more copyrighted works during any 180-day period, which have a total retail value of more than $2,500. 2, shall be fined under this title in prison not more than 6 years or both if the offense is a felony and is a second or subsequent offense under subsection A. And 3, shall be fined under this title in prison not more than 1 year or both in any other case. D, whoever commits an offense under section 506A1C of Title 17, 1, shall be fined under this title in prison not more than 3 years or both. 2, shall be fined under this title in prison not more than 5 years or both if the offense was committed for purposes of commercial advantage or private financial gain. 3, shall be fined under this title in prison not more than 6 years or both if the offense is a felony and is a second or subsequent offense under subsection A. And 4, shall be fined under this title in prison not more than 10 years or both if the offense is a felony and is a second or subsequent offense committed for purposes of commercial advantage or private financial gain under subsection A. 3, in subsection F, A, by amending paragraph 2 to read as follows. 2, the terms reproduction, distribution, and public performance refer to the exclusive rights of a copyright owner under paragraphs 1, 3, 4, and 6, respectively, of section 106 relating to exclusive rights in copyrighted works, as limited by sections 107 through 122 of Title 17, and B, in paragraph 3, by striking and inserting a period, and C, by striking paragraph 4 and 4 by adding at the end the following new subsection. G, evidence of total retail value. For purposes of this section and section 506A of Title 17, total retail value may be shown by evidence of 1, the total retail price that persons receiving their reproductions, distributions, or public performances constituting the offense would have paid to receive such reproductions, distributions, or public performances lawfully. 2, the total economic value of the reproductions, distributions, or public performances to the infringer or to the copyright owner as shown by evidence of fee, advertising, or other revenue that was received by the person who commits the offense, or that the copyright owner would have been entitled to receive had such reproductions, distributions, or public performances been offered lawfully. Or 3, the total fair market value of licenses to offer the type of reproductions, distributions, or public performances constituting the offense. C, rule of construction. Any person acting with a good faith, reasonable basis in law to believe that the person's conduct is lawful shall not be considered to have acted willfully for purposes of the amendments made by this section. Such person includes, but is not limited to, a person engaged in conduct forming the basis of a bona fide commercial dispute over the scope of existence of a contract or license governing such conduct where such person has a reasonable basis in law to believe that such conduct is not infringing. Nothing in this subsection shall affect the application or interpretation of the willfulness requirement in any other provision of civil or criminal law. Section 202, trafficking in inherently dangerous goods or services. Section 2320 of Title 18 United States Code is amended 1, by redesignating subsections B through G as subsections C through H respectively. 2, by striking subsection A and inserting the following. A, offenses. Whoever intentionally 1, traffics in goods or services and knowingly uses a counterfeit mark on or in connection with such goods or services. 2, traffics in labels, patches, stickers, wrappers, badges, emblems, medallions, charms, boxes, containers, cans, cases, hang tags, documentation, or packaging of any type of nature, knowing that a counterfeit mark has been applied thereto, the use of which is likely to cause confusion, to cause mistake, or to deceive. 3, traffics in goods or services knowing that such good or service is a counterfeit military good or service, the use, malfunction, or failure of which is likely to cause serious bodily injury or death, the disclosure of classified information, impairment of combat operations, or other significant harm to a combat operation, a member of the armed forces or national security. 4, imports, exports, or traffics in counterfeit drugs, or attempts or conspires to violate any of paragraphs 1 through 3 shall be punished as provided in subsection B. B, penalties. 1, in general, whoever commits an offense under subsection A, if an individual shall be fined not more than $2 million, imprisoned not more than 10 years, or both, and if other than an individual, shall be fined not more than $5 million, and B, for a second or subsequent offense under subsection A, if an individual shall be fined not more than $5 million or imprisoned not more than 20 years or both, and if other than an individual, shall be fined not more than $15 million. 2, serious bodily injury or death. A, serious bodily injury. Whoever knowingly or recklessly causes or attempts to cause serious bodily injury from conduct in violation of subsection A, if an individual shall be fined not more than $5 million, imprisoned for not more than 20 years or both, and if other than an individual shall be fined not more than $15 million. B, death. Whoever knowingly or recklessly causes or attempts to cause death from conduct in violation of subsection A, if an individual shall be fined not more than $5 million, imprisoned for any term of years or for life or both, and if other than an individual shall be fined not more than $15 million. 3, counterfeit military goods or services. Whoever commits an offense under subsection A involving a counterfeit military good or service. A, if an individual shall be fined not more than $5 million, imprisoned not more than 20 years or both, and if other than an individual be fined not more than $15 million. And B, for a second or subsequent offense, if an individual shall be fined not more than $15 million, imprisoned not more than 30 years or both, and if other than an individual shall be fined not more than $30 million. And 3, in subsection D, by striking D and inserting D, defenses. 4, in subsection E, by striking E and inserting E, pre-sentence report. 5, by amending subsection F as redesignated to read as follows. F, definitions. For the purposes of this section, 1, the term counterfeit drug has the meaning given that term in section 201G2 of the Federal Food, Drug, and Cosmetic Act, 21 U.S. Code 321G2. 2, the term counterfeit mark means A, a spurious mark, 1, that is used in connection with trafficking in any goods, services, labels, patches, stickers, wrappers, badges, emblems, medallions, charms, boxes, containers, cans, cases, hang tags, documentation, or packaging of any type or nature. 2, that is identical with or substantially indistinguishable from a mark registered on the principal register in the United States Patent and Trademark Office and in use whether or not the defendant knew such mark was so registered. 3, that is applied to or used in connection with the goods or services from which the mark is registered with the United States Patent and Trademark Office, or is applied to or consists of a label, patch, sticker, wrapper, badge, emblem, medallion, charm, box, container, can, case, hang tag, documentation, or packaging of any type or nature that is designed, marketed, or otherwise intended to be used on or in connection with the goods or services for which the mark is registered in the United States Patent and Trademark Office. And 4, the use of which is likely to cause confusion, to cause mistake, or to deceive. Or B, a spurious designation that is identical with or substantially indistinguishable from a designation as to which the remedies of the Lanham Act are made available by reason of Section 220506 of Title 36. But such term does not include any mark or designation used in connection with goods or services, or a mark or designation applied to labels, patches, stickers, wrappers, badges, emblems, medallions, charms, boxes, containers, cans, cases, hang tags, documentation, or packaging of any type or nature used in connection with such goods or services of which the manufacturer or producer was, at the same time of the manufacture or production in question, authorized to use the mark or designation for the type of goods or services so manufactured or produced by the holder of the right to use such mark or designation. 3, the term counterfeit military good or service means a good or service that uses a counterfeit mark on or in connection with such good or service, and that A, is falsely identified or labeled as meeting military specifications, or B, is intended for use in a military or national security application, and 4, the term financial gain includes the receipt or expected receipt of anything of value. 5, the term Lanham Act means the act entitled an act to provide for the registration and protection of trademarks used in commerce, to carry out the provisions of certain international conventions and for other purposes, approved July 5, 1946, 15 U.S. Code 1051. 6, the term traffic means to transport, transfer, or otherwise dispose of to another for purposes of commercial advantage or private financial gain, or to make, import, export, obtain control of, or possess with intent to so transport, or otherwise dispose of. 6, in subsection G, by striking G and inserting G, limitation on cause of action. 7, in subsection D, by striking H and insert H, report to Congress. Section 203, protecting U.S. businesses from foreign and economic espionage. A, for offenses committed by individuals. Section 1831A of Title 18 United States Code is amended in the matter after paragraph 5. 1, by striking 15 years and inserting 20 years. And 2, by striking not more than $500,000 and inserting not less than $1 million and not more than $5 million. B, for offenses committed by organizations. Section 1831B of such title is amended by striking $10 million and inserting not more than the greater of $10 million or 3 times the value of the stolen trade secret to the organization, including expenses for research and design or other costs of reproducing the trade secret that the organization has thereby avoided. Section 204, denying U.S. capital to notorious foreign infringers. A, identification and recommendations regarding notorious foreign infringers. 1, in general, using existing resources, the Intellectual Property Enforcement Coordinator, in consultation with the Secretaries of Treasury and Commerce, the United States Trade Representative, the Chairman of the Securities and Exchange Commission, the Registrar of Copyrights, and the heads of other departments and appropriate agencies, shall identify and conduct an analysis of notorious foreign infringers whose activities cause significant harm to the holders of intellectual property rights in the United States. 2, public input. In carrying out paragraph 1, the Intellectual Property Enforcement Coordinator shall solicit and give consideration to the views and recommendations of members of the public, including holders of intellectual property rights in the United States. B, report to Congress. The Intellectual Property Enforcement Coordinator shall, not later than 6 months after the date of enactment of this Act, submit to the Committees on the Judiciary of the House of Representatives and the Senate a report that includes the following. 1, an analysis of the notorious foreign infringers and a discussion of how these infringers violate industry norms regarding the protection of intellectual property. 2, an analysis of the significant harm inflicted by notorious foreign infringers on consumers, businesses, and intellectual property industries in the United States and abroad. 3, an examination of whether notorious foreign infringers have attempted to or succeeded in accessing capital markets in the United States for funding or public offerings. 4, an analysis of the adequacy of relying upon foreign governments to pursue legal action against notorious foreign infringers. 5, a discussion of specific policy recommendations to deter the activities of notorious foreign infringers and encourage foreign businesses to adopt industry norms that promote the protection of intellectual property globally, including addressing A, whether notorious foreign infringers that engage in significant infringing activities shall be prohibited by the laws of the United States from seeking to raise capital in the United States, including offering stock for sale to the public, and B, whether the United States government should initiate a process to identify and designate foreign entities from a list of notorious foreign infringers that would be prohibited from raising capital in the United States. Section 205, defending intellectual property rights abroad. A, resources to protect intellectual property rights. 1, policy. The Secretary of State and the Secretary of Commerce, in consultation with the Register of Copyrights, shall ensure that the protection in foreign countries of the intellectual property rights of the United States persons is a significant component of United States foreign and commercial policy in general and in relations with individual countries in particular. 2, dedication of resources. The Secretary of State and the Secretary of Commerce, in consultation with the Register of Copyrights and the heads of other appropriate departments and agencies, shall ensure that adequate resources are available at the United States Embassy or diplomatic mission, as the case may be, in any country that is identified under Section 182A1 of the Trade Act of 1974, 19 U.S. Code 2242A1, to ensure A, aggressive support for enforcement action against violations of the intellectual property rights of the United States persons in such country. B, cooperation with and support for the host government's efforts to conform it to applicable laws, regulations, practices, and processes to enable the host government to honor its international and bilateral obligations with respect to the protection of intellectual property rights. C, consistency with the policy and country-specific priorities set forth in the most recent report of USTR under such Section 182A1. And D, support for holders of United States intellectual property rights and industries whose access to foreign markets is improperly restricted by intellectual property-related issues. B, new appointments. 1, appointments and administration. The Secretary of State and the Secretary of Commerce, in consultation with the Register of Copyrights, shall appoint at least one intellectual property attaché to be assigned to the United States Embassy or diplomatic mission, as the case may be, in a country in each geographic region covered by a regional bureau of the Department of State. The Director of the Patent and Trademark Office shall maintain authority over hiring, personnel ratings, and objectives for the attachés in consultation with the Secretary of State. Depending on experience and expertise, intellectual property attachés shall be designated as the diplomatic rank in mission of First Secretary or Counselor. 2, regions defined. The geographic regions referred to in paragraph 1 are the following. A, Africa. B, Europe and Eurasia. C, East Asia and the Pacific. D, the Near East. E, South and Central Asia and the Pacific. F, the Western Hemisphere. 3, duties. The intellectual property attachés appointed under this subsection shall focus primarily on intellectual property matters, including the development, protection, and enforcement of applicable law. Each intellectual property attaché shall work in accordance with the guidance from the Director and in coordination with appropriate staff of the Department of Commerce and State of the Copyright Office to advance the policy goals and priorities of the United States government. Those policy goals and priorities shall be consistent with the USTR's reports under Section 182A1 of the Trade Act of 1974. The intellectual property attaché shall work with the United States holders of intellectual property rights and industry to address intellectual property rights violations in the countries where the attachés are assigned. C, priority assignments. 1, in general, subject to subparagraph 2, in designated United States embassies or diplomatic missions where attachés will be assigned under subsection B, the Secretary of State and the Secretary of Commerce shall give priority to countries where the activities of an attaché are likely to achieve the greatest potential benefit in reducing intellectual property infringement in the United States market, to advance the intellectual property rights of the United States persons and their licenses, and to advance the interests of United States persons who may otherwise be harmed by violations of intellectual property rights in those countries. 2, assignments to priority countries. In carrying out paragraph 1, the Secretary of State and the Secretary of Commerce shall consider assigning intellectual property attachés, A, to the countries that have been identified under Section 182A1 of the Trade Act of 1974, 19 U.S. Code 2242A1, and B, to countries of critical economic importance to the advancement of United States intellectual property rights and interests. D, training. The Secretary of State and the Secretary of Commerce shall ensure that each intellectual property attaché appointed under subsection B is fully trained for the responsibilities of the position before assuming duties of the United States Embassy or diplomatic mission to which the attaché is assigned. E, coordination. The activities of intellectual property attachés under this section shall be determined in consultation with the Intellectual Property Enforcement Coordinator. The Director shall assist in coordinating the policy priorities and activities of intellectual property attachés and oversee administrative and personnel matters. F, training and technical assistance. 1, consistency. Using existing resources, all training and technical assistance provided by intellectual property attachés appointed under subsection B or under other authority relating to intellectual property enforcement and protection abroad shall be designed to be consistent with the policy and country-specific priorities set forth in the most recent report of USTR under Section 182A of the Trade Act of 1974. 2. Role of IPEC. Such training and technical assistance programs shall be carried out in consultation with the Intellectual Property Enforcement Coordinator. The Director shall assist in coordinating the training and technical assistance programs conducted by intellectual property attachés. G. Activities in other countries. In the case of countries that are not identified under Section 182A1 of the Trade Act of 1974, the activities of federal departments and agencies with respect to intellectual property rights in those countries, intellectual property programs and outreach to the United States government in those countries, and training and technical assistance programs of the United States government relating to intellectual property in those countries may be conducted to the extent they are consistent with compelling commercial or foreign policy interests of the United States. H. Reports to Congress. The Intellectual Property Enforcement Coordinator shall include in the annual report submitted under Section 314 of the Prioritizing Resources and Organization for Intellectual Property Act of 2008, 15 U.S. Code 8114, on the activities of the Advisory Committee established under Section 301 of that Act, 15 U.S. Code 8111. Information on the appointment, designation for assignment, and activities of all intellectual property attachés of any federal department or agency who are serving abroad. 1. Definitions. In this section, 1. Director. The terms Director of the Patent and Trademark Office and Director mean the Undersecretary for Intellectual Property and Director of the United States Patent and Trademark Office. 2. Intellectual Property Enforcement. The term Intellectual Property Enforcement has the meaning given that term in Section 302 of the Prioritizing Resources and Organization for Intellectual Property Act of 2008, 15 U.S. Code 8112. 3. Intellectual Property Enforcement Coordinator. The term Intellectual Property Enforcement Coordinator means the Intellectual Property Enforcement Coordinator appointed under Section 301 of the Prioritizing Resources and Organization for Intellectual Property Act of 2008, 15 U.S. Code 8111. 4. Intellectual property rights. The term intellectual property rights means the rights of holders of copyrights, patents, trademarks, other forms of intellectual property, and trade secrets. 5. USTR. The term USTR means the United States Trade Representative. 6. United States person. The term United States person means A. Any United States resident or national. B. Any corporation, partnership, other business entity, or other organization that is organized under the laws of the United States. And C. Any foreign subsidiary or affiliate, including any permanent foreign establishment of any corporation, partnership, business entity, or organization described in subparagraph B that is controlled in fact by such corporation, partnership, business entity, or organization. J. Authorization of appropriations. The Secretary of State and the Secretary of Commerce shall provide for the training and support of the intellectual property attachés appointed under subsection B using existing resources.
Mr. Chairman?
Thank you for that reading.
Mr. Chairman, it's procedural.
The gentleman from Illinois.
Could you ask you to read that middle section again?
Mr. Chairman, I would like to recommend that the clerk be given a raise for a very good job.
Certainly a cold glass of water. Thank you for that reading.
Reserving the right to object. Okay.
I'll recognize myself for an opening statement, then the ranking member. Quote, the bill in Congress now, critics say, goes much too far. The Internet's potential could be crippled. The bill could turn out to be the executioner of the Internet's real promise, end quote. With all the strident and unfounded claims that have been made about H.R. 3261, the Stop Online Piracy Act, one can be forgiven for thinking those words were written about this bill. But those words were published 15 years ago, and the bill that critics targeted for defeat was the measure that eventually was signed into law as the Digital Millennium Copyright Act, or the DMCA. A dozen years later, Wired magazine called it the law that saved the web, and wrote, quote, blogs, search engines, e-commerce sites, video, and social networking portals are thriving today thanks in large part to the notice and takedown regime ushered in by the much maligned copyright overhaul, end quote. In hindsight, what so many had attacked and feared helped promote and advance their interest. It is my view that providing new effective tools to combat the theft of intellectual property online will similarly promote the interest of all stakeholders. While the DMCA helps, it only applies in limited circumstances. It provides no effective relief when a rogue website is foreign-based and foreign-operated like Pirate Bay, the 89th most visited site in the U.S. It doesn't protect trademark owners and consumers from counterfeit and unsafe products like fake prescription medications available on legitimate appearing but unlicensed online pharmacies. It doesn't assist copyright owners when foreign rogue sites are devoted to the theft of intellectual property on a massive scale. And finally, it does nothing to address the use of intermediaries, such as payment processors and Internet advertising services that are employed by criminals to fund illegal activities. That's why the Stop Online Piracy Act is needed. This bill will make it more difficult for those who engage in criminal behavior to reach directly into the U.S. market to inflict harm on American consumers. Laws equip U.S. authorities and right holders to take action against criminals who operate within our borders, but there is no parallel authority that permits effective action against criminals who operate from abroad. The situation has deteriorated to the point where the Register of Copyrights testified before this committee last month, quote, "It is my view that if Congress does not continue to provide serious responses to online piracy, the U.S. copyright system will ultimately fail," end quote. As of this morning, typing "download movies for free" into Google will take you to sites like Pirate Bay that offer free copies of infringing films and TV shows. While the Internet should be free, it should not be lawless. The problem of rogue websites is real, immediate, and increasing. It harms companies across the spectrum, and its scope is staggering. One recent survey found that nearly 1/4 of global Internet traffic is infringing. The resultant economic losses run into the hundreds of billions of dollars every year. Since the U.S. produces more intellectual property than any other country, our citizens have the most to lose if we fail to engage and implement meaningful solutions. I believe the manager's amendment addresses the legitimate concerns that have been expressed, including protection of the First Amendment, due process, and the integrity and security of the Internet. The manager's amendment also includes provisions that ensure the protection of the Internet and its underlying system. It makes clear that no harm can come to domain name system security extensions, DNSSEC, by eliminating any requirement to direct or redirect users to another site. It protects the security and integrity of the DNS by establishing a kill switch that will allow a provider to not carry out an order upon a finding that it would impair the security or integrity of the system. The amendment ensures that the bill cannot be construed to require any order that would harm the DNS and requires a study to ensure no DNS harm. This is a good bill that is the product of an extensive process that has involved members on both sides of the aisle. The manager's amendment improves the legislation, increases industry support, and ensures the promotion of American innovation and the protection of U.S. jobs. I encourage members of the committee to support the amendment. Look forward to working with all who are committed to enacting an effective and comprehensive measure. While that concludes my opening statement, I recognize myself for a unanimous consent request. The Stop Online Piracy Act has broad support across the aisle here in the House, across the street in the Senate, and across the country. There are about 150 organized supporters of H.R. 3261, and here are some of the groups that support the bill: ABC, AFL-CIO, American Society of Composers, Authors, and Publishers, Americans for Tax Reform, Alliance for Safe Online Pharmacies, Comcast, NBC, Universal, Copyright Alliance, Council of Better Business Bureaus, Council of State Governments, ESPN, Major League Baseball and the NFL, Major County Sheriffs, Motion Picture Association of America, National Association of Manufacturers, National Cable and Telecommunications Association, National Center for Victims of Crime, National District Attorneys Association, National Governors Association, National League of Cities, News Corp, Pfizer, United States Conference of Mayors, United States Chamber of Commerce, Visa, and MasterCard. Without objection, a list of organizations in support of the bill will be made a part of the record. The gentleman from Michigan, the ranking member of the Judiciary Committee, Mr. Conyers, is recognized for his opening statement.
Thank you, Chairman Smith. We have an incredibly large number of organizations, labor unions, businesses, individuals, scholars that have joined us in the bill, and I think that you have done a service to this piracy problem by offering a manager's amendment first. Now, I know nobody was unhappy or mad, and I'm sure that everybody feels better now that, how many pages was that? No, how many pages was the 74? 71. I lost track somewhere around the 22nd or 3rd page, but I'm sure it benefited a lot of people that didn't know what the manager's amendment was, now you heard it. And we will have a small test afterward to determine how much you remembered about it. But all we're trying to do here is stop online piracy. Now, since when did the opposition get so fierce against this? What could be behind the motives of people or organizations that don't think stopping online piracy is something that we need to deal with? It can only be handled by the Judiciary Committee, and that this manager's amendment clarifies the provisions so that the bill applies only to foreign rogue websites. It removes language that would have required redirection when users try to access an unlawful site. It makes clear that an action by the Attorney General, service providers will not be required to block subdomain. The manager's amendment narrows definitions in 1, 2, 3, 4 particulars. And then it even goes as far as removing the voluntary notice section for rights holders, which means they're no longer required to provide notice to payment processors. And so victims of intellectual property theft will continue to use current voluntary market-based systems to address counterfeiting and piracy. But it maintains immunity for financial institutions and online service providers. What more do you want? I mean, what is the operative motive behind us taking steps that have cost us hundreds of thousands of jobs, that have that is good for our business and commercial interests? And so I appeal to every member of this committee, whatever purpose, philosophy, or motive that they may have, to seriously realize that this is a bill that has the support of the other body, of leaders in all walks of life, and the time's come for us to put our shoulder to the wheel here. And if you want 65 amendments to be debated and voted up and down, fine. I plan to be here no longer than the House is in session, which mercifully will come sooner rather than later. So I'm ready to go next year, next month, and any time that it takes. If somebody thinks that a bill of this magnitude is going to be stalled because we get tired, they got the wrong thing coming. And I yield back my time.
Thank you, Mr. Conyers. The gentleman from Virginia, the chairman of the Intellectual Property Subcommittee, Mr. Goodlatte, is recognized.
Mr. Chairman, thank you for holding this markup today of the Stop Online Piracy Act. And I want to also thank the ranking member of the full committee, Mr. Conyers, and the ranking member of the Intellectual Property Competition and the Internet Subcommittee, Mr. Watt, for the hard work that they have also put in to this legislation. The Internet and technology sectors in America are economy-changing industries. They continue to usher in new products and services, new ways of communicating and doing business, and jobs. Content owners are also economic drivers and employ millions to supply new and creative ideas and products which fuel the demand for the devices and technologies that deliver those products. The fact of the matter is that these two job-creating industries and many others that do business on the Internet all need each other, and a successful fight against intellectual property theft must include these industries working together in addition to legislation to solve the problem. However, we are here today to address a gaping loophole in the ability of content owners to enforce their intellectual property rights, their patented goods, their copyrighted works, their trademarks, to enforce them overseas. It affects the very decision of whether they will continue to create new products and services. U.S. innovators have strong tools at their disposal to enforce their property rights against thieves here at home, but they are severely limited when the theft occurs overseas. While it continues to be a tremendous transformational medium, the Internet has also made it easier than ever in the history of the world to steal others' ideas and works. This unfortunate reality hits American entrepreneurs particularly hard because they continue to be the world leaders in innovation. America's entrepreneurs are increasingly being left with no option other than to sit and watch as their products and ideas are stolen by overseas thieves, copied and distributed throughout the world with the click of a mouse. To add insult to injury, these unauthorized products and services almost always make their way back to consumers within the United States. Not only does this illegal activity destroy the incentives for American entrepreneurs to create new products and services and jobs, it is also very dangerous. When counterfeit medicine with dangerous ingredients, fake automobile brakes made of sawdust, or phony military equipment are sold to U.S. buyers, the consequences can be disastrous. The Stop Online Piracy Act preserves the vital incentives that are necessary for entrepreneurs and authors to continue investing in new inventions, writings, and products. It gives American innovators tools to limit the damaging repercussions of foreign theft and thereby protect the value of their investments. The bill allows federal law enforcement to go to court to seek an injunction against a foreign website that is dedicated to the theft of U.S. property. If the court agrees that the foreign site is dedicated to the theft of U.S. property, it can ask payment processors to block financial transactions to those illegal sites, advertising networks to stop selling ads to those illegal sites, search engines to stop returning results to those illegal sites, and ISPs to disable U.S. access to those illegal sites. The bill also grants authority to innovators themselves to petition a court to declare a foreign website as dedicated to the theft of U.S. property. This private sector remedy is very limited, however. First, a content owner is not allowed to seek the remedies of blocking a foreign website or blocking hyperlinks to a foreign website. Those remedies are reserved only for the cases brought by federal law enforcement. In addition, a content owner is not allowed to sue any intermediaries, such as credit card companies or advertising networks. The content owner is simply allowed to seek a declaration that a foreign website is breaking U.S. law. If a court agrees, the court, in its discretion, can order payment processors or advertising networks to block transactions to that illegal offshore website. This legislation was not perfect when it was introduced, and I have worked hard with Chairman Smith and others to ensure that this manager's amendment incorporates many of the recommendations of the technology community, First Amendment rights advocates, and others. I still do not believe this legislation is perfect, and I look forward to continuing to work with all affected parties to further hone the bill as it moves forward. However, the bill is a good one, and I look forward to reporting it out of the committee. The Stop Online Piracy Act will strengthen the ability of American inventors and creators to enforce their property rights overseas, which will make the protections our framers envisioned over 200 years ago relevant in the digital and global marketplace. This will in turn encourage more innovation in the U.S., more investment in that innovation, and more American jobs. Mr. Chairman, I yield back.
Thank you, Mr. Goodlatte. Mr. Goodlatte, I join you in thanking Mr. Conyers and Mr. Watt for their partnership in this effort, and I also want to express my appreciation for all your hard work on this legislation as well. The gentleman from North Carolina, Mr. Watt, the ranking member of the Intellectual Property Subcommittee, is recognized.
Thank you, Mr. Chairman. Mr. Chairman, I'm a pretty old-fashioned guy who still hasn't figured out how, even whether I want to use all the fancy technological advances that are out there. But as I've evaluated the issue of online piracy over the last several months, it has been both informative and increasingly alarming to me the extent to which these criminal enterprises can flourish unabated over the Internet. Music and movies, handbags and airbags, perfumes and pharmaceuticals, toothpaste and toolkits, you name it. It's been or will be the target of pirates intent on turning a quick buck without any regard for the grandmother whose health is put at risk, the first responder whose equipment is inadequate, the artist whose work is misappropriated, the worker whose job is eliminated, and perhaps, as disturbingly, the young person who is socialized to think getting other people's stuff free or cheap is perfectly acceptable behavior. This issue is not only about protecting the health and safety, intellectual property, competitiveness, and economic growth of our nation. It's also about preserving who we are as a nation. I believe that at our best, we are a nation of checks and balances. In this context, an open and free Internet is not unduly compromised by measured efforts to halt the documented proliferation of counterfeits and piracy online. I believe the manager's amendment that will be the base text for the markup today constitutes such an effort. So I want to thank the chairman for working with us, particularly on Title II related to the sentencing provisions, and for being receptive to making key changes in Title I and elsewhere in the bill in response to legitimate concerns on the First Amendment and due process issues raised about the introduced bill. Before and after the Stop Online Piracy Act was introduced, we heard a number of legitimate concerns from various stakeholders and advocacy groups about some of the provisions in the core part of the bill. We were urged to limit the bill to authorize only follow-the-money actions by the Attorney General, with the exclusive responsibility for enforcement on payment processors and ad agencies. Despite those pressures, I am pleased that while making significant revisions to the definition of the targeted site, shoring up due process and First Amendment protections, and providing sufficient time for intermediaries to act, the manager's amendment still retains a two-track enforcement structure which is more likely to lead to more effective outcomes. Entrusting both the Department of Justice and private rights holders with authorities to engage multiple intermediaries against foreign infringing sites will afford enhanced opportunities to prevent the exploitation of U.S. citizens and the infiltration of our markets with inferior, stolen, and dangerous products. Now, Mr. Chairman, I'm aware that there are some people out there who think that the Internet is like Las Vegas. Whatever goes on in the Internet stays on the Internet, and regardless of whether it's criminal activity or sinister activity, we don't want to tax it, we don't want to interfere with it, but we have some laws in this country deal with brick and mortar things that don't apply in the internet, and we need to be just as aggressive in the internet when it comes to criminal activity as we are with brick and mortar stores. We don't let pawn shops operate freely without, we don't ask them to monitor what they get in the pawn shop, but we do have the authority to go into that pawn shop and figure out where criminal activity is taking place. And I think this bill really does exactly that. It allows us to get into the internet and say, look, you can't engage in these kind of just because it's taking an internet. That you would be able to get away with it. So, from my perspective, just as an old country boy, and, you know, world, what we have in the real world, and I think this bill draws the appropriate balance to get us into that space. And while I'm happy to continue to work on it, the manager's amendment has gone a way in some and I get back.
The chair and recognized members. The amendments have been grouped based on the section of the manager's amendment that they amend. Within each group,
famous New York restaurant
between Republicans and Democrats in order of seniority, with reference to those amendments that were pre-filed. Amendments filed late yesterday or today will be considered later in the markup, regardless of the section they amend. Are there any amendments to the amendment? The gentleman from Iowa is recognized.
Thank you, Mr. Chairman. I have an amendment.
The gentleman from Iowa will suspend.
I had hoped to move to strike the last word to comment on the manager's amendment.
The gentlewoman is recognized for 5 minutes.
I wanted to talk about the amendment in its entirety because I think it's important to have an overview of the manager's amendment itself. We will discuss various elements through the amendment process, but I think from cybersecurity to technical experts, the bill's impact on the security of the Internet and the integrity of the basic infrastructure of the Internet is very much at risk. We've heard from civil libertarians about the bill's inconsistencies with the constitutional rights to free speech and due process, and we're mindful that today is the birthday of the First Amendment. We've heard from entrepreneurs and venture capitalists about how the bill could stymie online innovation, from human rights and religious freedom advocates about how the bill could make it impossible for the United States to stem the tide of Internet censorship around the world. And I think it's important to think and contemplate what is at stake here and what we are doing here, because I do think it's historic. Some have said that the Internet is lawless. The Internet is not lawless. Conduct on the Internet can break the law and can be punished just as in the physical world. But up to this point, our government has always gone after the criminality on the Internet at each end of the network. It's shut down the illegal conduct at its source. It's punished Internet users for what they use the Internet for, but it's never tried to use the communication network itself to make illegal conduct impossible. If this bill passes with the mandate for domain name and other Internet filtering intact, I think it will be historic and not in a good way. I don't think they'll be going back. I think once the government has a taste of this power, the temptation to exert an ever greater amount of control over the Internet through filtering technology will be irresistible. The U.S. government has never tried to monitor mail sent through the post office to prevent some category of illegal content from ever being sent. We've never tried to filter the telephone networks to block illegal content on the telephone network, and yet that is precisely what this legislation would do relative to the Internet. There's nothing wrong with shutting down illegal conduct at its source or investigating and punishing illegal conduct when it happens online, but I think there is something fundamentally wrong with checkpoints in communications networks in an attempt to prevent illegal communications from ever being transmitted in the first place. Right now, there's a struggle going on worldwide. Foreign governments like China and Iran already are using some of the same technology that this bill encourages to censor the Internet. These same governments are striving to gain control of the Internet's basic infrastructure through authority asserted by the United Nations and the International Telecommunications Union. If this bill passes, I believe it will aid this push for more direct government control, and I think it's going to be even harder for the United States to resist it. As Secretary of State Hillary Clinton put it just last month, and I quote, "Fragmenting the global